I want to welcome you all here today for the 6th annual Frey Lecture on Intellectual Property. This lecture has come to play an important role in the strength of Duke Law School's menu of intellectual activities, encompassing a broad range of scientific inquiry and technological innovation where intellectual property plays a key role, including biotechnology, telecommunications, health, and the environment. As the choice of this year's speaker reflects, the focus at Duke is distinctively interdisciplinary, with productive connections being drawn between intellectual property and economics, philosophy, political theory, public policy, computer science, and artistic creation. The intellectual activities at Duke, including this lecture series, have explored the core relationships between business, innovation, entrepreneurship, politics, and property, and cross-national as well as disciplinary boundaries. On behalf of the institution, I want to say how grateful I am for the donors whose generous gift makes this annual lectureship possible, Kip and Meredith Frey, who are here with us today, and also how thrilled I am that we were able to persuade this year's lecturer, Dr. Joseph Stiglitz, to come to Duke. To introduce Dr. Stiglitz, I will turn the podium over to Professor Jerome Reichman.
Thank you, Kate, and particular thanks to Kip and Meredith Frey for making this wonderful lecture series on intellectual property possible. We also want to thank David Lang for working with the Freys to arrange this lecture series, and not incidentally, for also having brought James Boyle, Jerry Reichman, and Artie Wright to Duke. We also want to thank our precious colleagues at Fuqua and the Sanford Public Policy Institute, Tracy Lewis, Wes Cohen, Jim Anton, Bob Cook-Dagan, and Anthony So, among others, who have so enriched our intellectual property program. We are all delighted to have Professor Stiglitz with us today to discuss the economic foundations of intellectual property law. As you know, in 2001, Professor Stiglitz received the Nobel Prize in Economics for his groundbreaking analysis of markets with asymmetric information. He helped to create a new branch of economics known as the economics of information, and he's continuing his pioneering work in that area, as we learned this morning in our conversations with him. On the academic side, he taught at Yale, Princeton, Stanford, MIT, Oxford, and is now at Columbia. On the public service side, he served as on President Clinton's Council of Economic Advisors and chaired it for 2 years. He then became chief economist at the World Bank, and he took his book, Globalization and Its Discontents, has been translated into 35 languages and sold more than 1 million copies, and now he has another book out there, Making Globalization Work. We invited Professor Stiglitz to deliver this lecture not only because he is an eminent and pioneering scholar, researcher, educator, and public servant, but because of the importance of his work on the increasing globalization of intellectual property. In particular, he has focused on perceived impediments that intellectual property seems to be putting in the way of both innovation and world development, despite special interest claims that intellectual property is the key to innovation and worldwide development. As a member of President Clinton's Council on Economic Advisors, he is on record as having opposed the TRIPS Agreement of 1994, which elevated international intellectual property standards for some 145 members of the World Trade Organization. He said then that, quote, it was bad for American science, bad for world science, and bad for developing countries. 10 years after the TRIPS Agreement, this topic is more controversial than ever. Some leading developing countries, notably Brazil, China, and India, have increasingly entered the intellectual property arena with a growing number of patents and innovations. And yet their governments have protested strongly against the imbalances in TRIPS and in later free trade agreements. And they have lobbied for a more development-friendly agenda at the World Intellectual Property Organization and the World Trade Organization. Professor Stiglitz's group at Columbia, the Initiative for Policy Dialogue, has established a task force on intellectual property to investigate these matters more systematically, and I am privileged to serve as a member of that team. Meanwhile, Professor Stiglitz himself has increasingly focused his formidable analytical powers on these matters, and he has published a series of papers and speeches challenging much of the received rhetoric about intellectual property. We have asked him here today to share his insights with a broader audience under the auspices of the Frey Lecture. We are honored that he has accepted our invitation, and it is my great privilege to invite him to the podium. Professor Stiglitz.
Well, it's a real pleasure to be here for a number of reasons. It's really been wonderful to be at a place where so many people are interested in intellectual property. When I was, as was mentioned, when I was in the White House at the Council of Economic Advisors, it was hard to get anybody interested in the subject of intellectual property, other than the USTR, who had the U.S. trade representative, whose view was the stronger the intellectual property regime, the better, and trying to explain to Mickey Cantor what intellectual property was and why it was important to get it right was a challenge. He nodded his head, but went off to Geneva with his own agenda, or I should say, with the agenda of the drug industry and the entertainment industry. The last night a question came up, when did my interest in this begin? And actually, my work in this area actually began some 40 years ago, a long time, when I realized, as I was beginning my work on the economics of information, I realized that knowledge and information are really very, very similar. In fact, you can view information as a particular kind of knowledge. And so the problems that I had described, analyzed, or was in the process of describing, analyzing at the time, in how well the market economy deals with information, also applied in a variety of ways to how well the market economy deals with knowledge. And I'll come and talk about that a little bit more. But what was clear is that the standard paradigms of well-functioning markets solving the problems Adam Smith's invisible hand just didn't work. Some of you may know one of the important results in my work in that area was to argue, Adam Smith's invisible hand was argued that individuals in the pursuit of their self-interest, maximizing profits, were led as if by an invisible hand to the general welfare, well-being of society. And what I had shown in a number of my papers was that the reason that the invisible hand often seemed invisible was that it wasn't there. And this had led me to a certain degree of skepticism about the standard perspectives on intellectual property. And as it was mentioned, when I was at the Council of Economic Advisors, we opposed TRIPS. Interestingly, so did the Office of Science and Technology Policy. So it wasn't as if we were alone. It was really it was really a view of most of the people who understood the issues versus most of the people who had some special interest on this issue. When I went to the World Bank, I continued, perhaps even more so, involved in the issue, because one of the things that separates developed and developing countries is not just the disparity, the gap in resources, but also the disparity in knowledge. And closing that gap in knowledge is an essential part of successful development. And the World Bank has an annual report called the World Development Report, where highlights every year a key issue. And the first year I was at the World Bank, we focused on the problems of knowledge, knowledge for development. And I included there a critique of TRIPS and what we call an unbalanced intellectual property regime. I view one of my minor victories was that I anticipated the U.S. Treasury's blood pressure would rise when they saw this. So I arranged that at the meeting of the board of the World Bank where this was going to be discussed, I make sure that we got strongly criticized from India. So it was right after the U.S. government, U.S. representative gave the predictable speech about how we were soft on intellectual property and had to revise our report. India spoke up, and then a couple of other countries, saying how that our report was in fact very unbalanced. It was too much pro-intellectual property. And that after their strong criticism, which we had welcomed, the U.S. decided not to pursue the issue anymore, lest they actually wind up with a report that was less favorable than the report that we had written. Well, the issue of intellectual property has become one of the major issues, I think, of our global society. Globalization is one of the most important issues of the day, and intellectual property is one of the most important aspects of globalization. And I mentioned that in my book that just came out called Making Globalization Work. I devote a whole chapter to the problem of intellectual property because I do think it is an important, an essential issue. As we talk about the knowledge economy, the new economy, the knowledge economy, how we regulate knowledge, rights to knowledge, becomes actually at the center of how well this new economy, the knowledge economy, works, who benefits, as well as both distributional issues and efficiency issues. Maybe at the beginning I should make clear my ambiguous feelings about intellectual property by mentioning a story of a couple stories of some of my first personal encounters with intellectual property. About 20 years ago, I got a letter from a Chinese publisher wanting me to write a preface to a pirated edition of one of my textbooks. And as a good academic, I think should, I was enthusiastic about the idea. Because my view was that the reason that we write these things is not to make money, but to influence ideas, to influence the shaping of the intellectual debate. China was beginning the transition to a market economy. If my book helped shape that in a successful way that enhanced the well-being of over 1 billion people, it would have been a major accomplishment, and one that, and looking at it even in more narrow terms, if even 1% of those 1 billion people read my book, it was probably a larger readership than I would get in America. Another example of the ambivalence, a little bit later, I was at a conference in Taiwan, and I knew that they had mixed feelings about, we would say now, inadequate enforcement of intellectual property rights. And we had a break in the conference, and I had a little time to go to a bookstore. And as I went to the bookstore, I had a debate in my mind about what I hoped to see when I got there. On the one hand, there was the risk that there was the possibility that they had stolen my intellectual property, that they had pirated one or more of my books. And of course, we all know theft is a terrible thing. And stealing intellectual property is a form of theft, and so that would be terrible. On the other hand, the other possibility was that they hadn't stolen my intellectual property. That is to say, they would have ignored me. And as I walked to the bookstore, I came to the conclusion that being ignored is far worse than having your property stolen. And I resolved that I would actually be much happier if they had stolen my intellectual property. And I got there, and in fact, they had stolen it. So I was relieved. Well, I think that sets, I hope, the tone of saying that we, as researchers, as academics, we believe that we want our ideas to be disseminated, to be, we work quite hard. In fact, going all kinds of places to disseminate our ideas. And that's very different from what intellectual property does, which is trying to restrict the use of knowledge in one way or another. And maybe I'm giving away my bottom line, which is I will take a view that's very critical of intellectual property. What? Dedicate? Right. Yeah. Let me begin by talking about the role of the intellectual property regime. It's part of a society's innovation system, and its intent is to provide incentives to innovate by allowing the innovator to restrict the use of that knowledge and thereby obtaining a return on his investment. But it's important as we think about IPR, patents, copyrights, various other parts of the intellectual property system, to realize that there are many other parts of a society's innovation system, that there are other ways of financing and producing research. For instance, universities, government-supported research labs. In fact, I would argue, perhaps modestly, that the most important ideas are not ideas that are generated, the most important ideas are ideas that are generated in the universities, and many of which are not covered at all by the patent system. If you look at the basic idea underlying the computer, Turing's idea, nothing was not protected, not protectable by the patent system. Ideas like asymmetric information are not covered by intellectual property. Sometimes maybe I wish that they were. I would probably be in a different economic position than I am. But I think it would have been a bad thing for society had these ideas been covered by intellectual property. While many of you who are academics may, by introspection, ask the question, what motivates you? It's clear that monetary returns is only a small part of what motivates you, or you wouldn't be here. The whole framework of what induces people to engage in research is really not captured by the intellectual property regime. Now, obviously, and I'm going to come to this, you have to finance research. It doesn't come for free. It takes resources. And it's that question, how do we motivate, but also how do we finance research? And that's an important distinction I'll come to in a minute. Another example of important development source of innovation is the open source movement, again, which is not based on IPR, important in many areas of software today. And as I said, in many areas of research and basic science, patents play a very small role. There are other ways of providing returns on knowledge than patents, trade secrets, there are first mover advantages, natural advantages, market economy. And there are still other ways that we can think of providing incentives, and one of them I'm going to talk about later, which is a prize system. It's actually been a part of the innovation system for several hundred years. Well, let's see if I did that. All right, I'm going the wrong way. Okay. Okay, the key question is the role of the patent system or the intellectual property regime within this broader innovation system, and more particularly the design of the patent or IPR regime. And there are a host of questions which absorb all the energies of all the lawyers answering, and at the level of superficiality that I'm going to be giving, I won't go into many of these. I'll hint at these at a couple points. But they address issues like what can be patented, the breadth of the patent, the standard of novelty, procedures, for granting patents, for challenging patents, the rules for patent enforcement, and the notion of responsibilities as well as rights. For instance, to get a patent, you have to disclose information. You're supposed to disclose enough information that somebody could replicate what it is. Typically, one doesn't do that, but or you try not to do that if you can get away with it. But the notion, I mean, this disclosure has long been an important part of the patent regime, intellectual property regime, arguing that this disclosure is one of the things that helps enhance, one of the reasons why IPR can enhance innovation, because people can build on that knowledge. And I'll come back to that again. Knowledge is the most important input into knowledge. But interestingly, in some of the more interesting recent intellectual property disputes, controversies, that notion is being contested. Microsoft has not wanted to disclose its code. The European Union has insisted that it do that, and it has done everything to not to comply with the EU requirement, even to the point of risking millions of dollars of fines. And like any property right, there are restrictions on the use. The fact that you have a property right doesn't mean that you can do anything with it. Somebody says, owning a bat doesn't mean that you have the right to hit anybody over the head with it. And in the case of intellectual property, one of the restrictions is you're not supposed to engage in abusive anti-competitive behavior. There are important rights of the issue, the rights of governments to issue compulsory licenses are an important part of the patent regime. One of the important responses to the abusive practices of anti-competitive practices has been restrictions on the use of patents, effectively compulsory license, forming patent pools. This is in the consent decree in the case of AT&T in the 50s. There was the notion AT&T had to make available its patents to anybody that wanted to use it. And I argued in my Tunney Act filing with respect to what should be done with the anti-competitive behavior of Microsoft, that there ought to be restrictions on its intellectual property as a way of dealing with its abusive practices, and argue that it actually would enhance, those kinds of restrictions would enhance innovation in our economy. Well, how these questions are answered, the role of the patent system, the design of the patent system, how these questions are answered can affect the efficiency of the economy and its innovativeness. There are large costs to the current patent system, and one of the questions is, are there reforms which will improve its efficiency? To understand or to answer these questions, one has to go back into might say, the economic foundations of what knowledge is, and I want to begin the discussion by talking about that. Knowledge, the basic idea here, and it's very important, is that knowledge is a public good. And this is a technical term, the way economists use it. And let me explain when we economists use the term public good. It's a concept that Paul Samuelson defined precisely just over 50 years ago. And the notion of a public good is a good, the consumption of which is non-rivalrous. Difference of a chair, only one person can sit in the chair. If I sit in it, it's more difficult for you to sit in it. Food, if I eat the food, it's more difficult, or you can't eat the food. So those are private goods that are, one person consumes it, another person can't consume it. Knowledge is different. One person, I've just told you some of the things I know, just a little bit, but now you know those things, but I also know them. Hasn't taken away what I know. Knowledge is it has this property of non-rivalrous consumption. Another way of putting it is that there's no marginal cost associated with the use. Thomas Jefferson put this much more poetically than economists did, and Paul Samuelson did not give a footnote to Thomas Jefferson. It was appropriation of Thomas Jefferson's property rights, but fortunately there were only at that time limited duration of patents and copyright. But the way he put it was that knowledge was like a candle. You can see this in the Jefferson Memorial. They use the word taper, but nobody knows what that word means anymore. Knowledge is like a candle. When one candle lights another, it doesn't diminish from the light of the first candle. And that is, the understanding that is at the core of understanding efficiency in knowledge. It's efficient to have knowledge distributed freely to everybody. Now, I'll come to, if that happened, it creates problems in providing incentives for the production, and that's the dynamic issue. But I want to first delineate efficiency in use means it should be freely available. The problem is that intellectual property circumscribes its use and thus almost necessarily causes an inefficiency. But not only does IP create a distortion by restricting the use of knowledge, it does something even worse. It creates an even worse distortion, monopoly power. I forget, you guys know who it was. Who was the judge who said monopoly is the supreme evil? Anyway, it creates a very large distortion in our economy. So, we have this quandary. Not only do we sanction this distortion, this inefficiency of restricting the use, creating monopoly power, I say not only do we allow it, it's part of our legal framework, and why? The reason is that we hope that it will promote innovation. But if we don't design it right, it may actually impede innovation. So that's where I'm going to be going with the argument. Before getting there, I want to point out that the social costs of this distortion are especially high in the case of life-saving drugs. One of the reasons that I opposed TRIPS so strongly was that the intent of TRIPS, one of the major reasons, the reason that the pharmaceutical industry was pushing for TRIPS was they wanted to make access to generic medicines, to reduce access to generic medicines. The reason that generic medicines are so disliked by the drug companies is the same reason why they're so liked by everybody else. Prices of generic drugs are very low. And the low price means that people will buy the generics, and the competition with the generics drives down the price of the pharmaceuticals and lowers their profits. And the context, to see the magnitude of this, that's gotten a lot of attention, is the AIDS drugs, but it's just one. In the case of AIDS drugs, the years treatment of the brand name drugs, not the most recent ones, but the older ones, the most recent ones are even more expensive, are $10,000 a year for a year's treatment. The brand name the generic drugs are now under $200. So if you are a poor developing country, your per capita income is $300 or even $3,000, you're not going to be able to afford $10,000. So when those trade ministers signed the agreement, the TRIPS agreement, in Marrakesh in the spring of 1994, they were in effect signing the death warrants on thousands of people in sub-Saharan Africa and elsewhere in the developing countries. And that is why this has generated such, not surprising, immense emotional and deserving concern. IPR is often used to leverage further monopoly power. The most obvious example is Microsoft, where it has used its monopoly power in intellectual property and monopoly power in operating system, to generate monopoly power in applications like Office and internet browser, and used this monopoly power in a very abusive way. The courts in the United States and the EU, Korea, have all, there's no disagreement about the fact that Microsoft has engaged in abusive anti-competitive practices. That should be clear. The only debate is what to do with it, because it has so much monopoly power that it's not easy to figure out how you deal with this problem. So it's not that, as I say, there is absolutely no debate about whether it has engaged in these abusive practices. It's only about how you deal with them. There's actually a long history of these kinds of abusive uses of intellectual property rights. Going back at the beginning of the last century, the automobile was one of the most important innovations. The airplane, and both of those, the success of those, the development of those were impeded by IPR. In the case of automobile, a patent was granted, an excessively generic patent was granted for a four-wheel self-propelled vehicle. Now, never mind that somebody else in the rest of the world might have had the idea before this person. America has always been a little bit provincial in this. Well, the United States, as you may know, gave a patent for basmati rice. Indians had thought they had been consuming basmati rice for maybe 1,000 or a couple thousand years, but the judge in Washington, or the patent office in Washington, obviously hadn't had the pleasure of eating basmati rice, and they thought it was a wonderful innovation, and granted a patent to it. And had India implemented the patent and enforced it, it would have meant that every time anybody in India ate basmati rice, they'd have to send a check to Texas to pay them for this idea that they had thought was theirs in the first place. Well, in the case of this automobile, the guy who got the patent had no intention of developing the patent of the automobile. He used it to form a cartel. And one of the things, those of you who have business school know that the best way of making money is not to come up with a better idea, but to form a monopoly, a cartel, restricting competition. Competitive marketplaces are very bad because they drive down prices and get rid of your profits. So the IPR is an important way of maintaining a cartel. And so most of the automobile companies went along with that, except for one. There was one innovator who had a different conception of what the automobile was about, and that was Henry Ford. He had the idea of a people's car, low price, that was totally inconsistent with the cartel's view of a high price, restricted usage. And he challenged the patent. Had he not had the resources and the determination, he would not have challenged it and would not have succeeded. He eventually succeeded. If he had failed, the development of the automobile would have been delayed for a long time. Given the concerns about global warming, that might have been a good thing, but that was not one of the issues that was on the agenda at the time. See, ordinarily, property rights are argued for as a means of achieving economic efficiency, but intellectual property rights, by contrast, result in a static inefficiency which could only be justified by the dynamic incentives. Now, I want to foreshadow something I'm going to come to a little bit later. Of course, any method of raising funds for innovation has a social cost. In the case of monopoly, it raises the way you raise it is the disparity between the price and the marginal cost. But the patent system is not an optimal way of raising money. It's not an optimal tax. It creates a particular set of distortions, and that's why it's particularly objectionable. Recent advances in industrial organization suggest that these costs may be far higher than previously thought. It is interesting that standard competitive equilibrium theory paid very little attention to innovation. The basic ideas that Chicago economics is based on, the Arrow DeBrew model, assumed that technology is fixed. You might say, isn't that strange for economists? How could economic theory pay any attention to models that assume technology is fixed in a dynamic economy? Well, that's something that probably somebody in the sociology field ought to address. But it is the standard paradigm, the reigning paradigm, that ignores innovation. But there was and in most first-year graduate courses in economics, most textbooks until my textbook came out, simply didn't talk about innovation in any systematic way. But there was a strand of thought associated with Joseph Schumpeter's Schumpeterian competition that did focus on innovation and argued that this competition for innovation resulted in temporary monopolies, but it was one monopoly after another, and so that you got a sequence of competitive competition. It was this kind of Schumpeterian competition, as it was called. But one of the results that in my earlier analysis was pointing out that Schumpeter was just wrong about the temporary nature of monopoly. Once monopoly power, once established, can easily be perpetuated. In fact, there's an incentive to perpetuate that monopoly power. And it's particularly evident in the case of network externalities, where there are, and situations where there are important switching costs, including learning. And that's one of the reasons why Microsoft is so difficult to deal with. Even if we stop the bad practices that led it to having created its monopoly power, the monopoly power persists after those bad practices have been terminated. So the recent advances suggest that these economic costs may be higher, maybe more last longer, but also that the benefits may be lower. In particular, that the incentives for R&D may be less, and the distortions in the direction, there may be important distortions in the way money is spent, that is to say, in the direction of research. And there, of course, there's some further costs that, I guess some of these things, it depends on whether you view these as costs or benefits. Transaction costs for lawyers are a benefit because they're the source of income, just like the transaction costs in Social Security. If we move out of Social Security to a private Social Security system, those were viewed by Wall Street as a benefit because the higher transaction costs are somebody's income. But from the point of view of social perspective, these administrative costs are a social cost, and they are high. And it also introduces a high level of uncertainty. Of course, there's always an intrinsic uncertainty of research, but it's compounded by the risk of patent infringement and the associated risk of litigation. But let me now turn to the issue. If the patent system is to be justified, given all its cost, it's only in terms of dynamic efficiency. And so that raises the question, can one obtain these dynamic benefits at lower cost? And what I'm going to try to argue later on is that I think, at least in some cases, it can. But interestingly, the worry is that the patent system may not, because of the way it's poorly designed, may even be slowing down the pace of innovation. So it's not that the patent system is encouraging innovation, it may have an adverse effect on innovation. And the fundamental problem, and it's important to understand this, the fundamental problem is the rewards do not correspond to the marginal social returns. So this is, and everything after this is really follows from this, that the patent system does not reward people on the basis of what is the marginal social return of their contribution. It's a proxy for that, and it's a very bad proxy. And a result of that, it introduces a distortion. And everything after this is, in a way, of second, third, and fourth best economics. And so that really is, in one sense, the critical insight. The marginal social return is having the innovation available earlier than it otherwise would have been. That is to say, if the idea was going to happen anyway, by somebody else, then your contribution is just that the idea occurred a little earlier. For those of us who write articles, this is always a very frustrating thing. We like to ignore this. We think that, if I had not solved the problem of how markets with asymmetric information worked, the problem would not have been solved. But the reality is that I know that somebody else would have done it, maybe the next day, or certainly the next month, or the next year, or maybe 10 years, but it would have happened. So I can't really claim that the contribution wasn't really solving it. It was really solving a little bit faster than anybody else did. And that's what ought to be rewarded, if you believe in rewards corresponding to people's marginal social returns. And economic efficiency requires that people's compensation is related to their marginal social returns. A clear case where you saw the distinction between what the people got and what the marginal social returns has to do with the Human Genome Project. Many of you know that this was a major project of decoding the human genome, an international effort, and that certainly by the early 90s, it was clearly underway, clear view that it would be done within a few years. Some debate about when it would be done, but it was pretty clear that it would be done within a few years. There was a race, though, among the private entrepreneurs to get it done a little faster. And they were willing to spend lots of money to get it done a day faster, a month faster, maybe at most a year faster. Why? Because if they could get decoded, identify a gene, say the gene for a breast cancer, if they could get it done a year earlier, they would have a patent. And that would mean that anybody who wanted to get it tested to know whether they had a likelihood of getting breast cancer would have to pay a huge amount of money. They would have a monopoly on the use of this gene. And Myriad got this patent. It's been using, or I would say abusing, this patent. There are others who have been willing to make the diagnostic test free, but because they say, no, it's ours, we own your gene. You might think that you own it. No, they own it. And to do this test, you have to pay, if you pay market price, several $1,000s. And the result of this is, of course, that if you don't have insurance, and more than 50 million Americans do not have insurance, it means that you cannot afford, for most of these people who don't have insurance, their income are limited. They can't afford the several $1,000s that you have to pay, and they're not getting the test, and many of them will die as a result of not having the appropriate diagnostic tests. So that's a case where there's clear social cost and no benefit, or a very little benefit. The benefit was getting it 1 year or 1 month faster than it otherwise would have done. And a whole host of things, of examples of that kind. Interestingly, this is a case where other jurisdictions have taken another view. In the case of Ottawa, in the case of in Canada, they've said this is too outrageous. We will not allow this patent, and they've just not allowed it to be patented. And so people in Canada can get this test. There are further distortions associated with monopoly that I've already talked about. Monopoly does not have an appropriate incentive to do research in any case. And finally, much of the returns can arise from what is called enclosing the commons. I think Jamie was the first person to use that term, enclosing the commons. Taking something that ought to be in the public domain and privatizing it. And in this case, of course, when you're privatizing what is in the public domain, there is a cost but no benefit. And this is evident in the controversy over biopiracy. Concept, I don't know how many of you know the concept of biopiracy. It was first time I was introduced to the concept of biopiracy. I was in a small village, indigenous Indian village in the high Andes of Ecuador. And you always get astounded at what people will talk to you about, what they know about. And they may know less about a lot of things, but there's certain things that they know a lot about. They were, in one of the villages I was there, they were very worried about what I thought was going to happen to the euro-dollar exchange rate because it affected their sales to Brazil. And, but in this particular village, the mayor went on at great length about what was happening in Ecuador because of biopiracy. Biopiracy is the patenting of indigenous medicines, plants, a variety of indigenous ideas, traditional knowledge, by American and other foreign companies. And again, you know, taking what was in the public domain and privatizing it. An example, in a way, was basmati rice. Another example that is equally dramatic, in some ways more dramatic, is the healing property of turmeric. Turmeric is a kind of a spice root that has been known for its healing properties for hundreds, probably thousands of years in India. Two South Asian doctors working in the United States recognized that under American law, they thought they could get a patent on this. Even though it was known, as I say, in India, they knew that probably the patent examiner in Washington wouldn't know it. The view was it's not published. Of course, any of you know there's a difficulty of publishing things that everybody knows. Everybody except the patent examiner. So you have this problem of this catch-22. You can't publish it because it's known, but then if it's not published, it's not known. It's not prior art, and so you can't. You can get a patent. Well, so they got the patent, and so again the result is if India had recognized this and India had forced it, it would have meant that anybody in India that used turmeric for healing purposes would have to send a check to these Indian doctors in the United States in recognition of their patent. Well, it's obviously, this was not a patent that was generating research and advance of knowledge in any way. Well, why these are all help explain why it is that the returns to patents do not correspond to the social benefit. But I want to go further and explain why it is that patents may slow innovation. And the most important aspect of this is that knowledge is the most important input into the production of knowledge. And intellectual property restricts the input, restricts access to knowledge, and therefore, in other words, one way of thinking about it is think about any production process. If you increase the price of the input, it reduces the supply of the output. And the input is knowledge. You increase the price of the input, it reduces the output. And of course, incentives for innovation with monopoly are less than in more competitive marketplace. Monopolists can increase the profits by discouraging innovation by rivals and raising rivals' costs. One of the arguments against Microsoft, and I think a correct argument, was that this is what they did. And that, in fact, in one of the states, one of the charges brought against Microsoft was not only that Microsoft's behavior raised prices, but it actually slowed down innovation. And that argument was also an important part of the EU case against Microsoft. Another important problem with a patent system arises from the fundamental difficulty in defining what it is, what a piece of intellectual property is. In the case of land, you can stake out the land, you can describe the land, you still have boundary disputes, but pretty well you can define what it is, the piece of property that you're talking about. But intellectual property is different. It's very hard to define precisely what it is that is your property. And what else, therefore, what is in the public domain, what is somebody else's property. It doesn't have clearly longitude, latitude kinds of specifications. And the result of this is that you get what is called a patent thicket, and that patent thicket can impede innovation. Again, this is a problem that's been known for a very long time. The other, as I said, important innovation at the beginning of the last century was the airplane, and a patent thicket impeded the development of the airplane. There were, here in North Carolina, you know about the Wright brothers. You even have on your license plate. They got a Kitty Hawk here in 1903. They got some patents, but so did Curtiss Wright. And the problem was it wasn't clear if you wanted to develop an airplane, who you paid off. If you paid off both of them, what they both demanded, it didn't pay to develop the airplane. If you paid off only one, you risked the suit from the other. And so the airplane wasn't developed until World War I came along. World War I, it was recognized it was more important to be able to bomb Germany than to allow the patent lawyers to make money. So in that valuation of social benefits, they decided to have a patent pool. The government basically seized the patents and said, we'll determine how much is paid to whom. And the development of the airplane proceeded very quickly thereafter. Of course, not only is it the case that patents, as I say, may discourage innovation in generally, it also may lead to a distortion in the pattern of innovation. Our R&D activity can be directed at circumventing, on the one hand, monopolies, getting around a patent, or strengthening a monopoly. Clearly, arguably, one of the concerns about Microsoft's new Vista operating system is that it's being designed to make interoperability more difficult to strengthen its monopoly power. Contrast is creating new products and lowering costs which enhance welfare. So the point is that stronger intellectual property rights may not lead to faster pace of innovation. Well, I want to, as I said, one needs to look at the patent system, or copyrights, within the broader innovation system. And there are a number of tasks, as you look at that one wants to identify. This is not a complete list, but I think it identifies at least a partial list. The first is the selection of projects and researchers. You know, who is going to do research, what projects are going to be undertaken. The second one is financing. Knowledge is not costless, so there has to be some way of financing it. Risk absorption. Research is risky. You know, if you knew the outcome, it wouldn't really be research. There is an inherent uncertainty about research. You have to incentivize. I don't know if that's an English word, but you have to incentivize individuals to do work hard, and you have to disseminate the knowledge when it's produced. And the key attributes in evaluating different parts of the innovation system is how well they perform these roles, the cost they impose in the economic system. I already referred to the patent system's high distortionary cost. I didn't mean a high distortionary cost, as well as the transaction cost. Now, I would argue that a well-designed innovation system will be a mixed system. involving the patent and other things like government provision of research, basic research, university. And the question is, are we relying too heavily on the patent system? And particularly, is the patent system well designed for achieving the objectives, or should we reform it? The critique of the patent system is that besides the large static and dynamic distortions that I've just described, there is the problem of finance. As I said before, the way the system works is it's financed out of monopoly profits. That's how research is financed, out of the monopoly profits. But you can view conceptually the difference between the price and the marginal cost as a tax. In other words, you could think of this, it's equivalent to, you could think of this as a competitive system, but then adding on to that a tax on the marginal cost to bring it up to raise the price to the price that is charged. So you can think of the monopoly distortion as a tax with the revenue being used to finance research. Now, part of the problem is a lot of that revenue doesn't go to finance research. The drug companies spend more money on advertising and marketing than they do on research. And that's financed by that discrepancy. And of course, as you probably know, they spend more money on lifestyle drugs, like for hair, than they do on life-saving drugs. So there's a lot of what you might call leakage in this particular tax system. It's an inefficient tax system in delivering the revenue into research, which is where it's supposed to go. But putting that aside, you can ask, is it a good tax system? Is it a good way of raising revenue for financing R&D? And the answer is no. It has one desirable property, or actually I think it's an undesirable property, but it has one property that some people like. It's a benefit tax. That is to say, the only people who are paying for a heart medicine are the people who use the heart medicine. So there's a linkage between who benefits and who pays. But in most other areas, we do not believe it's a good thing to have a benefit tax, and we particularly don't believe that it's a good way of raising revenues for diseases, because one way of thinking about it is that it's bad enough that you have a heart problem, but then to say because you have a heart problem, you should also have to pay for the medicine, it is sort of like a double penalty. To put it another way, if you wrote down any utilitarian social welfare function, any Rawlsian social welfare function, any model, philosophical model of social justice, you would not, in the case of drugs, use a benefit tax. Okay, you just cannot justify it. There are other products in which a benefit tax might be justified, but not in the areas of life-saving medicines. But the other property is that it doesn't raise, it's a distortionary tax. And one of the major areas of public finance in the last 30 years has been to analyze what are the least distortionary tax systems. And the benefit tax is more distortionary and more inequitable than alternative tax systems. So the bottom line is the way we raise revenues for financing research through the granting of monopoly power is not one that could be justified by any principles of public finance. There's another problem which I think has not gotten adequate attention. I know among lawyers almost everything has gotten attention, so I feel a little nervous about this. But there is a bias towards excessive patenting. And that arises because there's an asymmetry between the granting of a patent and fighting a patent. When you get a patent, you enclose the commons. You make what otherwise would be public private, and so you get a private return. There's a private return for getting a patent. But when you challenge a patent, you create a public good. Because if you successfully challenge a patent, that piece of knowledge then becomes in the public domain. and anybody can use it. So challenging a patent is a public good. As in the case of other public goods, there's an undersupply of public goods. So the very structure of the patent system leads to a bias towards excessive patenting. The result, of course, is there will be underinvestment in fighting bad patents and an overinvestment in trying to get bad patents. And the problem can be exacerbated by bad procedures. There are, in addition, a number of inequities associated with IPR. I mentioned at the beginning of this talk that knowledge was a public good. In fact, it's a global public good, so the benefits could be enjoyed by anybody in the world. And the standard principles of equitable finance say that a public good should be financed by those most able to pay. But unfortunately, IPR does not, for the most part, recognize differences in circumstances other than the extent to which profits can be extracted. In other words, differences in elasticities of demand, but not any other circumstances, and therefore inherently will be inequitable. Moreover, the legal system can lead to unfair outcomes. The high cost of implementing IPR, including the high cost of challenging patents, puts developing countries at a disadvantage, exacerbating the risks of biopiracy. You know, one of the arguments was, don't worry about these biopiracy things. The patents won't survive. The answer is it's very expensive to challenge it. India is a rich, relatively rich, poor country, and it can afford challenging it, but Ecuador doesn't have the resources. And even in the cases where they've been challenged, one of the other examples of biopiracy is a variety of uses of neem tree, neem oil, which again is used, if you go anywhere in India, you can get neem oil used for a variety of purposes. The US and Europe granted patents on a large number of patents for a variety of uses of the neem oil, even though they have been known in India for a long time. In Europe, they were challenged, and the challenge was sustained. That is to say, the patents were overturned. But the U.S. refused to overturn the patents. So the neem patents continue in force in the United States, even though in another jurisdiction they've been overturned. One of the complaints I mentioned earlier was the access to generic medicines, and in the TRIPS agreement there was something that in WTO has its own vocabulary. They call it flexibilities. They have the flexibilities that allow people to issue generic medicines. The flexibilities are very inflexible, however. They're designed to make it difficult to get it. There are a whole set of procedures. If they really were interested in making sure that people had access to generic medicines, you would have designed a completely different set of procedures that would have looked very different. This is an issue that Pascal Lamy, who is the head of the WTO, has been very upset at my giving these lectures explaining how the WTO is causing people to die. He thinks this is an unfriendly act towards the WTO. So he wrote me and said, we've known each other for a long time, and said, you're forgetting about the flexibilities. But what he's forgetting about as I say, the inflexibilities and the flexibilities, and that in fact, exacerbating the problems is the fact that when other countries threaten to use a compulsory license, the United States comes down on them with like a ton of brick and says, if you do that, we'll take all kinds of other actions. And even when they are complying with all the rules of TRIPS. So it's not just that the rules were designed to make it more difficult, but the way they are being implemented makes it more difficult to get access to these generic medicines. This is probably one of the most important, most visible concerns of the developing countries, but there are a whole set of others. One of the complaints of the developing countries is that while they are being forced to pay high prices, brand name prices, the current system provides little incentives for R&D on diseases that afflict them. I mentioned that the drug companies are spending very little money, spending more money on marketing and advertising than on research, more money on research on life-saving drugs than on lifestyle drugs than on life-saving drugs. And almost all the money that they spend on life-saving drugs go to diseases of the advanced industrial countries. And that's predictable. One of the problems of being poor is that you don't have any money. And one of the problems, if you don't have any money, you can't spend a lot of money on drugs, even though you'd like to. I mean, even though if you don't spend the money, you die. So they clearly have a potential demand there. They only have the income, but they don't have the income. So the drug companies, of course, realize this, and they've made it some of them have been very upfront about it, and said, we cannot solve, the patent system does not provide us the incentive for developing cures, vaccines for the diseases that afflict developing countries. It's taken a long while, but finally, the World Health Organization has also recognized that the intellectual property regime is not addressing these concerns. The other concern is the one I mentioned in the beginning, which separates developing and developed countries, is the gap in knowledge, and TRIPS has made it more difficult to close that gap. More broadly, even advocates of free trade, like Jagdish Bhagwati, argue that TRIPS should never have been part of the WTO. At the same time, as I've already made clear, it provides little protection for their intellectual property. And it's not just the issue of biopiracy, it's protection of biodiversity. And although this is not just TRIPS, the fact is that the U.S. has refused to sign the Biodiversity Convention that was intended to provide some protection for their biodiversity. The result of this is that the developing countries have called for a development-oriented intellectual property regime. It should be clear that there is no reason to expect that the design of an IPR system which balances costs and benefits, which is optimal for the United States, would be optimal for a developing country. And they are, as a result, calling for a more balanced intellectual property regime. Well, I want to just conclude by, as I said, arguing that we want to view IPR as part of an innovation system, that there are other parts of this innovation system, government-supported research, for instance, grants are an important part, probably the most important part in supporting basic research, and basic research is obviously a very important part of our innovation system. I want to talk very briefly about an alternative called the prize system, which gives a prize to somebody who comes up with innovation. For instance, you say, if you come up with a cure for AIDS or a vaccine for AIDS, you get a big prize. If you come up with a cure for malaria, you get a big prize. If you come up with a Me Too drug with slightly different side effects, you might get a small prize. So you could calibrate the prize with the nature, the magnitude of the contribution. This idea is actually an old one. I was giving a talk in Edinburgh as part of the book festival last August on my new book, Making Globalization Work. And my lecture was sponsored by the Royal Society of Arts and Technology. And they were extremely enthusiastic about, and I discussed this idea in that book, and they were extremely enthusiastic because they say they've been advocating this for 200 years. And actually not only advocating it, using it. Jamie was pointing out that They, for instance, they thought it was important to come up with an alternative to chimney sweeps. You know, they used to send boys down chimneys, and they had to be small, so they didn't feed them so they could get down the chimney. And it was obviously not exactly a socially desirable way of cleaning your chimneys, but not cleaning your chimneys meant that you risk fires at serious consequences. And so they offered a prize for somebody coming up with a mechanical way of doing that. And it worked. This prize provided incentives, and an idea, something came up. There are a whole host of things where they have offered prizes. The notion is that the prize, the current system is a kind of a prize system, but it's a very inefficient one because the prize is the monopoly power. And the monopoly power means that there are incentives to restrict the use of the knowledge. And so remember, if you go back to what I said before, the characteristic of a desirable innovation system, one of the characteristics is dissemination, usage of the knowledge. And this system is one which is designed to restrict the use of knowledge. Well, the alternative is to use the competitive market to ensure the efficient dissemination. So with a competitive market where you, say, license to large numbers of people, you use the force of competition to drive down the price and to increase the usage of the knowledge. So you use market forces in both cases. One is the market forces, the incentive to restrict knowledge, raise the prices. The other is the market forces of competitive markets to drive down the prices and disseminate knowledge. Moreover, it has the advantage that there's less waste on advertising, other anti-competitive behaviors designed to enhance monopoly profits. Any of you who studied how the drug companies, I mentioned that they spend more on advertising and marketing than they do on research. There's a good reason for this. There's a return on this. It's not just providing information to the market. Most of what they do, to the extent there's some information, it would be more disinformation if they could get away with it. But it's mostly oriented, you can actually look at it intends to reduce the elasticity of demand, which allows them to raise the price and increase their monopoly profits. So they have incentives to spend money to reduce elasticities of demand and to enhance monopoly profits, which from the point of view of a social point of view is dissipative. There are a number of ways of trying to design the prizes that I don't have time to talk about. One of the ideas that many people who've become aware of the problems of the current system have advocated is a guaranteed purchase fund, where the World Bank or the Gates Foundation would guarantee $1 billion, $2 billion if somebody came up with a vaccine for AIDS. For eggs. So you say, okay, we know that poor people can't afford it, but we can guarantee you $1 billion or $2 billion. And that is like a prize, guaranteed. But it maintains the inefficiency of the monopoly system. If you think that guarantee is enough to motivate people, and it clearly is, it's far better to use that guarantee to buy the patent and make it available freely than to use the monopoly system. Well, what I try to do here is to, in a little chart, summarize some of the attributes of these alternative systems. As I say, my view is that you will want to go towards a portfolio. The first attribute I talked about was selection. The advantages of both the patent and the prize system is that they are decentralized based on self-selection. Those who think that they are the best researchers make that decision, go ahead, and think that they're going to win the prize. So it has that advantage. Over the government-funded, where you have a group of peers, bureaucrats you can call them, deciding who is the best researcher. And people worry about capture and so forth. On the other hand, one of the disadvantages of both the patent and the prize system is the lack of coordination. one of the risks that each researcher faces is he doesn't know how many other people are engaged in that research. That increases the risk, and in some cases could actually discourage innovation. We were having a discussion earlier about the Bayh-Dole. One of the arguments for Bayh-Dole was that it may have an advantage of reducing, of enhancing the ability to coordinate. But in that sense, if you think of that important, it goes against both the patent and the prize system. The government funded can be obviously more coordinated in the structure of the selection problem. In the finance, the patent system is the worst. It's highly distortionate and inequitable. And the government funded can use, because it is less restrictive, is obviously the most efficient. In terms of risk, the patent system is the worst because of the huge amounts of litigation risk. The government is the best because it has the advantages of paying for the input rather than the output. That is to say, you get money for doing the research, whereas in the prize and the patent system, you only get money if your research is successful. So there is a very big difference in the nature of the risk in these areas. The reason that risk is important is in equilibrium, consumers have to pay for the risk. Somebody has to pay for that risk. People in general, firms are risk averse, and if there's risk, they have to be compensated for it. So the fact that the system makes people bear that risk, one has to remember, they don't bear the risk without getting compensated for it. So society, the rest of society, bears the cost of that risk, and that is one of the costs associated with the patent system. The innovation incentives are strong with the patent system, but they are distorted, whereas the price system can have equivalent, at least strong innovations, but less distorted. But the government funded, based on input, cannot work when the objective, the problem with the prize system is that it cannot work when the objective is not well defined. Finally, in terms of dissemination incentives, it's most limited with the patent. The prize and the government funded can be much more positive use of knowledge. The transaction costs, the distortions in the economic system are much higher with the patent system than with the other two. So let me conclude. IPR, intellectual property, is obviously important, but I think the importance of IPR has been exaggerated. It is only one part of our innovation system. It needs to be seen as part of a portfolio of instruments. I would argue that we need to strengthen the other elements of this portfolio and to redesign IPR to increase its benefits and reduce its cost. Thank you.
Thank Dr. Stiglitz for that fascinating, hefty, very high content talk. I'm sure many of you have questions. There is to be a reception outside this lecture room right now. So please join us out there. Thank you again for coming.
Oh, you